Good morning. My name is Asanya Urdu, and today I will be talking about staff leasing services, the way they basically have an impact on Texas workers' compensation in the state of Texas. Now, if you're not familiar with staff leasing services, think about a company that has a practice of actually hiring employees and assigning them to go work specific jobs. Perhaps a consultant going over to New York to go manage or consult a company for a 6 to 8 month period. And then once it's over, they come back and get ready for another assignment. Now, the way Texas operates when it comes to staff leasing services, there's an act that is actually governed, and it's known as the Staff Leasing Services Act. But from here on out, I'm only going to refer to it as the act itself, just the act. Now, under the act, a staff leasing company has the option to either choose to purchase workers' compensation for its employees, or they can elect not to. In situations where the staff leasing company chooses to actually purchase the workers' compensation benefit package, the company, and the client company, essentially who the employees will be going to work for, are being considered co-employers, in which, if there is an injury that takes place and an employee is injured while on the job, that means that the only remedy available for the injured employee is the workers' compensation benefits that are provided through the compensation that was acquired by the actual staff leasing company. That is the only exclusive remedy that is available to the injured worker. Now, in situations where the staff leasing company does not choose to purchase workers' compensation benefits, that provides an opportunity for the injured worker to file any claim, such as negligence, and not only against the staff leasing company itself, but also the client company who the employee was assigned to go work for. And another actual fact regarding not purchasing the workers' comp benefit is that the staff leasing company and the client company that the employee went to go work for cannot assert the traditional defenses that are often used in workers' comp claims, such as the employee failing to provide the employer with proper notice, statute of limitations, maybe even self-inflicted injuries. Those defenses are not allowed to be used by either the staff leasing company or the actual client company itself. Now, you're probably wondering what all is required to actually be in compliance with the Staff Leasing Act, or the Act. My apologies again. I said I was going to say Act the whole time. Pretty much, it's going to be a contract to determine the terms between the actual client company and the staff leasing company. And that is a huge factor regarding this whole agreement between the two. They're going to establish the terms as far as what's going to be provided, and also whether or not the actual staff leasing company will purchase workers' compensation for its leased employees. And it is mandatory that the workers' comp or the staff leasing company provides a copy of the written agreement to the actual leased employees. A key factor when it comes to the written agreement between the staff leasing company and the client company is that the staff leasing company must reserve the right to hire, fire, determine pay, the eligibility, and take the exclusive rights to dictate or control the actual workers' comp procedure. And this might sound a little confusing, but it's actually the contract itself will determine the exact relationship between the staff leasing company as well as the client company. And pretty much, it's just another benefit is that it will essentially bar the staff leasing company from trying to find protection for liability under the borrower servant doctrine, which will be another topic for another video. Now, talking about the act again, there is a condition that I must provide this information on. That just in the case that the actual staff leasing company chooses not to opt and purchase workers' comp benefits, and then the actual client company actually has workers' comp benefits for its employees, the actual client company is not required to pay the premium price for the leased employees. So think of it like this. Staff leasing company A leases its employees to a truck company, and the truck company has actual workers' comp benefits for its employees. Just because they lease companies from staff leasing company A does not require them to actually provide any workers' comp benefits or pay their premiums for the actual workers that they lease from the staff leasing company. If there are any other? Thank you for your time talking about Staff Leasing Acts and Staff Leasing Act requirements. I'm sure it sounds like a lot, and it was probably more than you could bear right now. If you have any questions, find us on MLFlegal.com.